Hi, Brandon Davis again with Davis CPA Group. Today I'm going to talk about estate planning. A lot of times when I'm working with my clients, particularly ones that have had businesses for a long period of time, amassed a little bit of wealth, I get a lot of questions about what they should do with that. Should they get a trust or should they get a will? And so we're going to talk about that a little bit today. Some of what we're going to talk about is going to border on some legal advice and things that we probably need to talk with our attorney friends just to make sure we're on point. But I'd like to just kind of give you an overview of different types of vehicles for estate planning, but also talk about a little bit of the tax implications of some of those things. So one of the things I get asked a lot of times is should I create a trust? And if I do create a trust, how does it work? Does it pay its own tax? What do I put in it? And so forth. And so a couple of things that I'll talk about, maybe three ways to maybe start the estate planning process and avoid things like probate and some of that we'll kind of jump into here. So whenever someone passes away, at the time of their passing, whatever assets they own, whether it's bank accounts, investment accounts, a house, a car, and what have you, they basically become part of that person's estate. And so what happens is we've got to figure out where these assets go, who do they transfer to, who are the next of kin that become the heirs of this property, and how do I, as a person while I'm living, control some of that? Well, you hear a lot about wills. We'll talk about that. You got trusts, and then you've got like TOD designations, transfer on death designations is what that stands for, or maybe beneficiaries, death benefits and things of that nature, for other terminologies. Wills basically are a document, it's a legal document that someone puts together and documents their wishes upon their passing. Now, a will does not necessarily avoid probate, and we'll talk about probate in a minute. But a will, at the very least, lets those who are charged with handling that person's affairs after they pass, whether it's another family member, a spouse, a child, or even someone that's appointed by the court system to handle that person's affairs and close out their estate, the will at least leaves a list of wishes that the person has. I want $10,000 in my bank account to go to my nephew Jimmy, and I want my house to be sold and all of the proceeds donated to a church or my favorite charity. They basically dictate that, and the person that's assigned to be in charge of that, who's usually called the executor of the estate, is generally supposed to follow that will through getting permission from the court and what have you. A trust is a little bit stronger in that it's a little bit different of an animal. A trust actually becomes its own entity. While someone's alive, they have what's called a living trust, or a trust that's disregarded for tax purposes. It's basically a legal structure that people have to title their assets in. And what I mean by title, one of the terms that attorneys use is to fund a trust. So a lot of times, I may have someone come in and say, I ask them, do you have a trust? Oh yeah, I got a trust. Okay, that sounds great. Are your assets titled in that trust? And they kind of look at it funny, well, what do you mean I got a trust? Isn't that good enough? The answer is no, it's not. Once someone creates a trust, which is a separate legal entity, they have to take additional steps, and usually their attorney helps them through this process to fund the trust. And how you fund the trust is actually transfer legal title to all of your assets that you want inside this trust to the trust name. A lot of times, say for example, I wanted to create a trust, I may call it the Davis Family Living Trust. And so we got this trust we're going to create, we'll call it the Davis Family Trust. Davis Family Trust. And while I'm alive, and one of the things I got to step back and say here, I'm talking about revocable trusts, meaning they can be changed. We're going to talk about irrevocable in a minute and what that means, but right now we're going to focus on a revocable trust, which I'm sure some of you may have heard that term before, not sure what it means. But basically it means it's a trust that I can change at any time. I am the creator or grantor of this trust, and I'm also the trustee while I'm living. A lot of times if I'm married, my spouse may be a successor or co-trustee, and we'll talk about that a little bit more later too. But I just want to kind of touch at a high level right now. So I have the Davis Family Trust. And once that's set up, in order to fund that properly, say I've got a house. Well, I've got to retitle my house with a deed into the trust. So I got to move my house into here. Maybe I have bank accounts. Well, I've got to put the bank accounts in the trust name and set that up. So I'll move that under here. Maybe some retirement accounts that I may have. Or maybe not. And there may be some tax implications why we don't want to put retirement accounts in a trust, and we can talk about that at a later date. But any assets, but if I certainly have just a regular investment account, I may want that in the trust. Now the nice thing about this is it does offer some layer or level of liability protections, meaning that another legal entity technically owns these assets. I don't own them. I control them because I'm the trustee of the trust, and it's changeable because it's revocable. So I can, spend all this money. I can sell my house. I can, liquidate all my investments. I can do whatever I want. I can buy, a boat with all of it and blow the rest on, trips to Hawaii or whatever. I can do whatever I want. What's interesting though is once I pass away, however I've documented my trust and it's set up, nothing can be changed. And then the beneficiaries basically are named, and my wishes within the trust document are adhered to. And who administers that is the trustee that I've named to take over once I pass away. So a trust is a little bit more of a firm document to establish your wishes, but also hold assets for distribution upon your passing. Another thing that a trust can do for you is give you some layer of flexibility and estate planning purposes. That's where we could talk about irrevocable trust, meaning trust that I can't change. If I set up an irrevocable trust and I move assets into that trust, I've effectively lost control of those assets. And so there could be some estate planning ideas and some different things you might want to look at relative to that. But that's kind of the simplest form what a trust will do for you. And going a little bit further, talking about transfer on death. Sometimes we talk about different things that we can do relative to estate planning, and we make things way more complicated than they need to be. A lot of times simple designations like transfers on death or beneficiary deeds on a house can accomplish everything we want to accomplish without having to go through these different steps as far as additional expense or additional sophistication in getting a trust done. So if I've got a situation where it's a simple husband and wife, maybe they've got a couple of kids, they've got a retirement account in their name, they've got a house, they've got some vehicles, and a little bit of savings, right? Simple, typical, run-of-the-mill American family situation. Well, they can avoid probate, and I'm going to touch on probate a little bit. What probate is, probate's a legal process. If I were to pass away and not have a trust in place, or had a will, or just had assets, when I pass away, those assets basically get allocated or dealt with through a probate system, where you basically go to court, you have an executor, usually an attorney involved, and when you go through that process, there is some cost. Well, when it's not as scary and bad as it sounds sometimes, particularly when people are talking about, oh gosh, I want to avoid probate. Well, all you do is have extra time and cost and a little bit more steps to go through to get the heirs those assets. Now, one of the things I'll say here is to avoid that, you can do transfer on death designations on a lot of these types of things. And so if you have retirement accounts, you certainly want to talk to the custodians of those accounts and say, hey, I want to leave 25% to my nephew and 50% to my kid, or 50-50 to my two kids, whatever. And it's called transfer on death designations or beneficiary designations. So you want to put those on your retirement accounts. The house, you can do something very similar to the house. You can actually file what's called a beneficiary's deed with the county that you reside in. And when you file that deed, it doesn't transfer the ownership. It basically says at the time of my passing, my house is going to go to whoever I've listed on that beneficiary's deed. So you can do a beneficiary's deed. The other thing on a vehicle, again, you can put a TOD on a title, which is a transfer of death designation on the title, and savings accounts and other bank accounts. You can generally do the same thing, do a TOD in those also. So by doing all of this, you've basically went ahead in advance of passing away, which is kind of morbid to talk about, I know, but you went ahead and planned out how you're going to allocate everything and where it goes, and really it won't leave much left for your estate to deal with and could avoid probate. So those are the three things that I just kind of want to talk about briefly as it relates to estate planning. In my next video, I'm going to dive a little bit deeper into trust, talk a little bit more about revocable trust, irrevocable trust, and taxation.